Welcome back to a new episode of our YouTube channel. I'm Jamie Alvarez and I'm here again with Matthew Comiskey, our managing attorney.
Thanks for having me back.
Thanks for being here. So Matt, we have mediation in almost every single case that exists. Tell us a little bit about mediation as it goes as far as foreclosure.
Foreclosure is a little bit different than what you might normally expect in a mediation. Many times when you step forward, and you know this as well as I do, having handled so many cases, that in a mediation normally it's about two different sides that are trying to vie for one winning out over the other. You know, it's about pointing out the deficiencies in the other side's case, pointing out the strengths in your own. We see this a lot when we're doing the civil litigation side of things, where we handle the insurance prosecution. That's where we have to come in there saying, this is the problems that you have with your case and that we're going to show to a jury. It's a different world when you work in foreclosure defense field. The reason why is that many times the cards are stacked against our clients. They've fallen on hard times. Many times people don't stop paying their mortgage because things are going amazingly for them. Life has happened. Medical debt has accrued. There's been a reason why they haven't been able to make ends meet and have gotten to this point. And that's why it's important for us to come in there with a solution. What we tend to do is we want to look through the finances. We want to see how we can figure out what debts can we move out of the way, whether that be Chapter 7 or a Chapter 13 bankruptcy, possibly in debt negotiation on other accounts. The key is finding a path that's viable moving forward, because that's how we find a successful mediation occurs. It's how we convince lenders to stop foreclosure sales so that we can get into a payment plan that will get us back into compliance with the mortgage.
Now, many people don't understand what mediation actually is. Mediation is where a person that is neutral is the head of the meeting that both sides come to. So you have the plaintiffs and you have the defendants. Each side puts on a little bit of what their case is about, but then they separate the parties. The parties are separated at that point so that they can talk freely to their attorneys and negotiate back and forth. The mediator is the one that goes back and forth in between rooms, which now we all use Zoom, so we have Zoom rooms for that as well.
And interestingly enough, as I've seen it, many times you actually will find that the mediator steps in and out of the room when you even separated yourself further, just so that it's you and your attorney. And the big part about that is having a conversation, a frank conversation about what the position is. Because many times when we step into a mediation, regardless of the area of law, there's where we want to be when we start. And sometimes mediations take turns left or right, and we have to reassess our position. Sometimes that's letting the mediator in on our thought process. Sometimes we want to make sure we do it just on ourselves so that we can make sure that we're on the same page moving forward before we start letting other people in.
Very true. Mediators are supposed to be neutral parties, and it's supposed to be a process that is not able to be heard by anyone else except those at the mediation itself. But even so, you have to feel comfortable speaking to your attorney directly and letting the mediator know, mediator, we do not want you to tell this information to the other side. We want you to understand so that you can help us further negotiate.
One of the big concerns I see whenever I'm doing a mediation is understanding the next step after mediation. And usually that's going to be moving into a trial. And so that's what somebody usually has to weigh against whether they should accept a settlement in a mediation. Whether it's worth them to roll the dice and go to, say, a 3, 4, 5-day trial before a judge and a jury, having to take the days off of work that's going to be required to do so, having to pay an expert to be there to explain our theory of the case to a jury. All of those have to factor into whether an offer is good or not. It's not simply a matter of dollars and cents.
That's correct. One of the things that I like to tell our clients is, this is your case and we will do what you want, but take into consideration the fact that we are trial attorneys. We love to go to court and put on a show. We've got all the bells and whistles, we have the screens, we have the pointers, we have everything that's necessary to put on a show for a jury to try and sway them to our side. The problem is, this is a matter of principle for you, but also it is a business decision. Is this something that you are willing to risk? If we lose, you may be liable for paying attorney's fees and costs on the other side. If we win, they will have to pay for our attorney's fees and costs. Is that something that you want to be in charge of? Or is that something where you would just want to say, hey, I would like to just settle today. Let's see as much as possible what I can get.
Whereas I see a lot in the foreclosure realm, you find that the trial, unfortunately, isn't going to deliver any sense of justice, that unfortunately the payment hadn't been made, and this is a ticking clock to a point where they're going to sell your home and you're going to be without. And so mediation is that point where you can stop the process. You can get into a payment plan where you can try to get yourself back to good, and that can hopefully stall out and make sure that nothing happens that can't be undone.
So Matt, let's say that you find yourself at a moment where your house is about to be sold. You haven't done anything, and the house, you're going to be sold on the courthouse steps. What do you do at that point?
Jamie, I can't tell you how many times I've heard that scenario. It's all too common. One of the biggest concerns that you have is, what can you do? You have to act immediately, and you have to talk to an attorney, because there are avenues that are available. Sometimes reaching out to the attorney is probably the first step that many people overlook. Simply calling up, trying to get a hold of either someone at the council or someone at their loss mitigation department. And all the banks do have these types of departments that are willing to talk to you about payment plans and such. If you can work together with your attorney to get into a payment plan, many times the attorney for the bank will file what's called a motion to cancel the sale, or will send a notice to cancel the sale if it's available to do that. The other option that some people choose is, based on their financials, they may be eligible to do a bankruptcy, whether that's a Chapter 13, which could strip away a second mortgage and maybe create some breathing room for the person, or whether that's a Chapter 7, which is a complete wipe. Either which way, when something enters the bankruptcy court, it's an automatic stay is entered, which would stop any foreclosure sales. This is a drastic move, and that's why it's really important that someone talk to an attorney prior to filing anything.
Now, all of these are steps and avenues that we have that we can show you so that you can make the decision on how you want to move forward in either saving your house or with your property insurance, any type of law really that you need help with. Shield Law Group can help you. So Matt, tell us a little bit about your other areas of law that you practice in.
A lot of my areas of practice are centered around civil litigation, land use and things like that. I would do cases where neighbors that had boundary disputes, neighbors that had to reassess where their lot line was. Let's say someone had erected a fence and no one knows exactly where it is. Unfortunately, it's all too common down here in South Florida where plats were not used to demark where the lot lines are for property. Many times a surveyor has to go out and actually describe the amount of distance and degree that one has to take to follow the boundary line for a piece of property. And when that happens, you can find neighbors who are all too confused about where one line ends and where the other starts. And so it's very important to make sure that you enforce the boundaries of your property. That's where I can come in and talk. I'm Matthew Comiskey of Shield Law. I'm the managing attorney here, and I really appreciate your time joining us here today. Please remember to click and subscribe if you enjoyed our content here, and I look forward to doing another video with you real soon.
We'll see you soon, Matt. Thank you.